Hello, my name is Kyla Smith, and the court case that I have is Santa Fe Independent School District v. Jane Doe of 2000. Facts. Santa Fe High School, a public school, used to have a student elected as student council chaplain, and that student would deliver a prayer over the school's public address system before each home football game. Two families, one Mormon and one Catholic, anonymously sued, claiming that the practice and others like it violated the First Amendment. While the lawsuit was pending, the school adopted a new dual election policy, whereby the students could elect whether to have invocations at games and the person who would give the invocations. The school's students elected to have the invocations, and they selected a spokesperson. Procedure. The district court allowed the new dual election policy, but ordered that the policy must permit only non-sectarian, non-proselytizing prayer. The Fifth Circuit reversed, holding that the school policy, even as modified by the district court, violated the Establishment Clause of the First Amendment. The district petitioned for a writ of cert, claiming its policy did not violate the Establishment Clause because the football game messages were private student speech, not public speech. The U.S. Supreme Court granted cert. Issue. Did the school's policy permitting student-led, student-initiated prayer at football games violate the Establishment Clause of the First Amendment? Yes. Holding, or court's decision. In a 6-3 opinion delivered by Justice John Paul Stevens, the court held that the district's policy permitting student-led, student-initiated prayer at football games, sanctioned by public school officials as part of the public school event, violates the Establishment Clause of the First Amendment. The court concluded that the football game prayers were public speech authorized by government policy and taking place on government property at government-sponsored school-related events, and that the district's policy involved both perceived and actual government endorsement of the delivery of prayer at important school events. Reasoning. The principles in this case are controlled by the court's decision in Lee v. Wiseman. In that case, which prohibited a rabbi from delivering a prayer at a middle school graduation, the court held that government may not coerce anyone to support or participate in religion or its exercise, or otherwise act in a way that establishes religion. The same is true here. There are three main arguments. Argument 1. Argument that the invocation is private speech. Argument 2. Argument that football games are voluntary. Argument number 3. Argument that the court's decision is premature. Disposition and dissent. The decision of the Fifth Circuit Court of Appeals is affirmed. In dissent, Chief Justice William H. Rehnquist, joined by Justices Scalia and Thomas, noted the disturbing tone of the court's opinion that bristled with hostility to all things religious and public life. The Establishment Clause, however, has let a little religion into public life at times. Further, there has been no constitutional violation yet, so the court's decision is premature. Implications on the community. Santa Fe Independent School District v. Doe is an important case because it carefully honors the Establishment Clause's promise to ensure that government, a public school in this case, does not establish one religion over others. The discrimination against those who did not agree with the majority's religious beliefs at Santa Fe High School was clear by the fact that the respondents felt the need to remain anonymous, as indicated by their name in the caption as Doe. The court's majority opinion, in fact, explained that the respondents were actually genuinely in fear of being discovered because the religious discrimination in the community was so severe. These are my references. Thank you all for watching.